Be ready. 5 seconds. Start. The present petition has been filed by the petitioner under Section 34(2) of the Arbitration and Conciliation Act 1996, hereinafter referred to as the said Act, CS number 150, page number 122, by which he is seeking setting aside of the ex parte arbitral award dated 8/2/2010. Along with the same, the petitioner has filed an application under Section 34(3) of the Act seeking condonation of delay of 232 days in filing the petition under Section 34 against the impugned award. Before adverting to the cases of the parties on merits, it is imperative for this court to consider whether the objection of the petitioner against the impugned award dated 8/2/2010 have been filed within time, and if not, whether the petitioner is entitled to condonation of delay in filing the same. Learned counsel for the petitioner has argued that the petitioner had no notice of either the arbitration proceedings or the making of the arbitral award dated 8/2/2010, and that he gained knowledge of the same only after receiving notice of the application filed by the respondent number 1 before the concerned civil court seeking execution of the award dated 8/2/2010. Counsel for the petitioner has submitted that in the evening of the 5/8/2010, the petitioner received summons issued from the Court of Civil Judge Kadkarduma of an execution application filed by the respondent number 1 against one Miss Bhavna, who was arrayed as JD number 1, and the petitioner, who was arrayed as JD number 2. Counsel submits that since the petitioner was not aware of any person by name of Srimati Bhavna or of any arbitration proceedings, he obtained a certified copy of the entire record of the execution application. After he was supplied the same, the petitioner came to know about the award dated 8/2/2010. The petitioner, CS number 150, page number 22, contacted his counsel to take appropriate legal recourse. Thereafter, on 25/10/2010, the present petition has been filed under Section 34(2) of the Act, along with an application under Section 34(3) of the Act seeking condonation of delay of 232 days in filing the said petition. Counsel for petitioner submits that the petitioner had no knowledge of the pendency of the proceedings before the learned arbitrator in the executing court as well as this court. The address of the petitioner has been mentioned as house number C 396, New Ashoknagar, Delhi 96, but till date he had not received any summons or notice of the arbitration proceedings. Counsel for the petitioner has argued that it is improbable that the petitioner would have received the summons passed by an executing court at the same address, but he would not have received the notices sent by the learned arbitrator regarding the initiation of arbitration proceedings and filing of statement of claim. Counsel has further submitted that from the perusal of the record of the arbitrator, it has come to light that a statement of claim had been filed by the respondent number 1 against Ms. Bhavna and the petitioner on the basis of a loan cum hypothecation agreement dated 11/2/2008, by which loan of rupees 1,16,000 was sanctioned by the respondent number 1 to Ms. Bhavna, and the petitioner Shri Nilesh was a guarantor. Counsel has submitted that at no point of time was the petitioner a party to the loan transactions entered into between Ms. Bhavna and the respondent, CS number 150, page number 322, number 1. He has drawn the attention of this court to the loan agreement documents filed with the statement of claim by the respondent number 1 before the arbitrator, and has argued that the loan documents were never signed by the petitioner Nilesh. He has further submitted that on the other hand, at the place of guarantor there is signature in Hindi of some other person by the name of Dheeraj. Counsel submits that since he was neither a borrower nor a guarantor, neither arbitration proceedings could have been initiated against him, nor could the award dated 8/2/2010 be passed against him. Counsel for the respondent has argued that the petition of the petitioner is barred by time, as whereas the award was passed on 8/2/2010, the present petition has been filed on 25/10/2010. Counsel for respondent number 1 has further argued that petitioner Nilesh was a signatory to the hypothecation cum loan agreement in the capacity of a guarantor, with the principal borrower being Ms. Bhavna. Counsel submits that the petitioner was always aware of not only the proceedings before the learned arbitrator as well as the impugned award dated 8/2/2010. He submits that petitioner has not shown any sufficient cause for condoning the delay in filing the petition against the award dated 8/2/2010.